Now starting. All attendees are in listen-only mode.
Good morning and good afternoon, as the case may be, everybody. My name is Doug Chasek. On behalf of Multifamily Insiders, the Apartment All-Stars, and the National Apartment Association Education Institute, welcome to Fair Housing webinar focusing on the deaf or hard of hearing. The National Fair Housing Alliance has filed 8 housing discrimination complaints recently with HUD against major apartment communities for discriminating against the deaf and hard of hearing across the country. NFHA conducted 304 tests of 117 apartment communities in 25 states, and here's what they found: that 1 out of 4 reportedly treated deaf and hard of hearing callers differently from hearing callers in a manner that appeared to violate the Fair Housing Act. According to one news outlet, the reported issues stemmed from testers who call apartment community leasing offices using an electronic system for the deaf and hard of hearing. The complaints say the representatives who took the calls at the properties may have hung up on callers using the service. So in light of this and other issues, NFHA and Multifamily Insiders and the Apartment All-Stars has asked a couple of experts to come in and share information with us about how to best serve our customers who may be deaf or hard of hearing. With us today, we have Deborah Patkin, who is a staff attorney with the National Association of the Deaf. Her job duties include litigating civil rights cases, advocating on behalf of the deaf and hard of hearing community, handling consumer inquiries regarding legal issues, and outreach and education. Prior to joining the NAD, she worked as a litigation attorney at the Disability Rights Legal Center in Los Angeles, California. Deborah received her JD from the UCLA School of Law. She also has a Master of Arts in Linguistics from Gallaudet University and a BS in Psychology from RIT. Deborah juggles her legal job with another job, being a mother. In her spare time, she enjoys rooting for Boston sports teams and doing outdoor activities such as hiking and biking. And our presenter today is Sheila Adams, the founder and CEO of S.J. Adams Consulting, and pardon me, Stella Adams. I apologize, Stella. My mouth is moving faster than my eyes. And S.J. Adams Consulting performs research and policy development in the areas of fair housing and fair lending. Ms. Adams served on the Federal Reserve Board Consumer Advocacy Council from January 2005 through December of 2007, and that council advised the board on the exercise of its responsibilities under the Consumer Credit Protection Act. She served as the chair of the Community Affairs and Housing Subcommittee. She currently serves as senior policy advisor for the Patricia Roberts Harris National Fair Housing Training Academy, providing subject matter expertise, technical assistance, and policy guidance to the academy, which prepares professional fair housing investigators to identify housing discrimination and predatory lending. Ms. Adams is a nationally recognized expert on the Fair Housing Act and implementing the regulations. She's also a nationally respected authority on predatory lending and mortgage fraud investigative techniques. Ms. Adams is the recipient of the 2012 Charles A. McLean Distinguished Service Award, the North Carolina NAACP, as well as numerous other awards, and she currently serves on a number of boards and commissions, including the National Community Reinvestment Coalition, the National Association of American Veterans, Inc., the North Carolina Fixed Debt Steering Committee, and the North Carolina State Conference of Branches of the NAACP. She is married to Thomas C. Adams and has 3 children. And Stella, I'm sure now you're blushing entirely too much, so let's turn it over to Stella Adams.
Hi, My name is Stella Adams, and I serve as a Senior Policy Advisor at the Patricia Roberts Harris National Fair Housing Training Academy. NFHA is a comprehensive fair housing training and educational institution established by Congress to provide core and specialized training in all aspects of fair housing and civil rights laws. I am honored to participate in the National Apartment Association's Fair Housing webinar focused on serving residents who are deaf or hard of hearing. I want to share with you some basic information about the Fair Housing Act and other laws that impact you as property managers. I want to explain your duty to respond to requests for reasonable accommodations and reasonable modifications by residents with deaf or hard of hearing. Under the Fair Housing Act and the Americans with Disabilities Act, I will also share with you the results of a national study which focused on how the industry responded to answering and responding to 711 relay calls. And finally, I will provide you with a list of resources that are available to assist you when working with clients who are deaf or hard of hearing. The Federal Fair Housing Act was passed in 1968 and made it unlawful to discriminate in the sale, rental, or financing of housing on the basis of race, color, religion, national origin, and sex. In 1988, the Act was amended to add familial status and handicap. However, we use the term disability. A person with a disability is defined as a person who has a physical or mental impairment which substantially limits one or more major life activities, a record of having such an impairment, or being regarded as having such an impairment. The Fair Housing Act prohibits landlords from refusing to rent, lease, or sell housing, setting different terms and conditions, falsely stating that housing is unavailable, engaging in discriminatory advertising, steering, blockbusting, and refusing to make reasonable accommodations, and sexual harassment. I have highlighted the refusal to rent, lease, or sell and falsely state that housing is unavailable for view or inspection as issues affecting persons who are hard of hearing or who have disabilities that impact their ability to communicate based upon findings of the very first housing discrimination study conducted by HUD on discrimination against persons who are deaf or hard of hearing. We will discuss this more later on. Some examples of reasonable accommodations include a building with no pets policy. You must allow deaf or blind tenants to keep trained service animals. A building or community that has an intercom or other coded entry system must provide an equally effective alternative for hard of hearing visitors or tenants to enter. For example, hard of hearing visitors and residents can connect through video monitors instead of an intercom. A condominium or homeowners association must provide interpreters to enable deaf or hard of hearing people to participate in the association's meetings. And that's really important. For example, tenants who are hard of hearing are permitted to install visible doorbells. The tenant may be required to pay for the modification and may have to restore the property to its original condition later. But landlords cannot forbid the tenant from installing the special equipment. Deaf or hard of hearing tenants often need special interior and structural designs that eliminate sight barriers. For example, color-coded strobe lights that alert residents to ringing doorbells and telephones. If it is publicly funded housing, the installation of the modifications are at the expense of the landlord. Landlords who accept tenant-based Section 8 vouchers must allow the modifications, but it is at the expense of the tenant. Please be aware that many state and local governments require landlords to provide free visual smoke detection alarms for deaf or hard of hearing tenants at no cost to the tenant. So be sure to check your local laws to ensure compliance. And as a landlord or property manager, you are required to provide a deaf or hard of hearing tenant or a tenant with communications difficulties with auxiliary aids and services to ensure they are not excluded, denied services, segregated, or otherwise treated differently than other individuals because of the absence of auxiliary aids and services. Unless you can show that it would fundamentally alter the nature of the housing being offered, or that the request would result in an undue financial and administrative burden, you cannot charge a fee to deaf or hard of hearing applicants or tenants to cover the cost of an interpreter if that becomes necessary for complex communications like an eviction proceeding. Be aware that the type of auxiliary aid or service necessary to ensure effective communication will vary based upon the length, nature, and complexity of the communication involved. The law does not guarantee a particular right to a sign language interpreter, but rather to effective communication. Don't panic. The major types of auxiliary services most landlords or property managers would need to provide are fairly simple. Answer and utilize the 711 TTY service that is available for communications at no cost. When a person with a hearing or communication difficulties comes into your rental or sales office, you can attempt to communicate through your written materials, floor plans, application procedures, tenant selection requirements, guest cards, and you can pass legible notes back and forth. If you have a tablet, you can type notes back and forth using your iPad or other device, or you can use video relay interpreters. Interpreters are generally necessary for complex communications or if the potential resident is illiterate. In addition to the Fair Housing Act, there are two other laws that protect the rights of the deaf or hard of hearing. The Rehabilitation Act of 1973, which was the first civil rights law protecting persons with disabilities, and the Americans with Disability Act, which was passed in 1990. Section 504 of the Rehabilitation Act of 1973 covers all federally funded or financially assisted housing and requires that reasonable accommodations are made for persons with disabilities and that 2% of all federally funded units are designed and constructed to meet the needs of persons who are deaf or blind. ADA covers the parts of housing that serve the public, including the rental and sales offices, pools, fitness centers, outdoor recreational facilities, any part that serves the public and not just residents and guests. ADA is often used in conjunction with the Fair Housing Act. In 2005, HUD conducted the first ever housing discrimination study of discrimination against the deaf or hard of hearing. The study focused on the treatment of deaf people who use the TTY system to inquire about advertised rental housing. Even after the call was explained, some providers gave no specific reason for not wanting to talk to the deaf tester, or they provided responses that constituted a violation of the law. Examples include statements like, "No, I don't want to speak with them." "No, we don't do that." "I can't do this right now. This is a business." "I don't want to talk to anyone. I don't know." When a rental housing provider refuses to take a call from a potential customer or refuses to provide any information about housing, he effectively denies access to any units he may have available. Many home seekers gather initial information about available rental options over the phone. For a hard of hearing person who communicates primarily through sign language, the ability to obtain information over the telephone is especially important. The decision by rental housing providers not to accept TTY calls essentially slams the door on these home seekers, making it impossible for them to conduct their housing searches independently. Many of the testers during the site visits had difficulty gaining access to buildings with intercom systems, which was an immediate barrier to housing choice. We talked earlier about the video intercom as an alternative. In many of the tests, effective communication was also an issue, and in others, there were differences in treatment observed in the information provided about the application process and the number of units that would be available. It is important that you know and understand any state or local fair housing and landlord-tenant laws that impact your business. Be sure to develop written rental, fair housing, and reasonable accommodation policies, and make sure that all of your employees have been trained and are aware of your rules, policies, practices, and procedures. Be consistent in the application of your rules, policies, practices, and procedures. And remember, exceptions should be well documented and rare. Document, document, document. Remember that a reasonable accommodation or modification request does not need to be made in any special way or on any special form. You are not entitled to diagnosis or prognosis. You are entitled to know how the requested accommodation is related to a limitation related to the disability. No is never, never the right initial response to a request for an accommodation. You need to determine if the requested accommodation or modification would represent an undue administrative and financial burden, or would fundamentally alter your programs or services. Then and only then do you begin an interactive process to determine if there is a way to meet the housing needs of the client in a way that addresses your concerns and allows them to enjoy the housing option. Thank you for allowing me to participate today. And here are a list of resources you can contact if you have any further questions or concerns related to today's topic.
Stella, thank you very, very much. Very comprehensive and very detailed. We appreciate it. And we do have a couple of questions here. The first one is if you could tell us a little bit more about how the 711 service works. You know, today we get all kinds of phone calls, we get unsolicited calls, we get what are commonly referred to as robocalls. How do we know that this is a 711 call or a TTY call when it comes in, please?
Deborah, our other panelist, is probably the better person to answer that question. Deborah, could you respond?
Sure. Just to explain briefly, the FCC has something called a relay service, but it takes different forms. So it's not actually limited to just TTY. That was sort of the first technology that gave deaf people access to the telephones. It looks almost like a little sort of mobile typewriter that attaches to the phone, and then that call goes to a relay operator or directly to another TTY machine. So that's one kind of relay service. But then we also do have another relay service that a lot of deaf people use that involves a webcam and the internet, or maybe IM, chat. It can even go through, you know, a mobile device. But basically the bottom line is that deaf people use a relay service to communicate with hearing people. So the deaf person would contact the relay operator, and that operator speaks to the hearing person on the other end of the line, and then communicates the message back to the deaf person. And it's actually, the newer systems are much more smooth and efficient than TTY. They rely on a video service. But if you do get a TTY or any sort of relay call, there will be a message from the relay operator saying, hello, this is a relay call. And so really, you know, the best practice, of course, is to educate yourself before you get that sort of call so that, you know, you as landlords and property managers are familiar with that sort of statement that you would hear from the relay operator, and so that you can recognize it and know that you're getting an actual relay call. But basically, the key is just to sort of listen for that message that announces that it is a relay call, whether that's a TTY or a video relay call. And also, the relay service, they'll never be trying to sell you something. They'll never be asking to buy something. In particular, they're just there to facilitate communication between the deaf caller and the hearing person that they're calling.
Great. Thank you very much, Deborah. Stella, can you put up the previous slide, please? And we're getting a bit of an echo. If we could mute. Let me get the mute on. Right, so we have several URLs here, and National Association of the Deaf is one site that I went to in preparation for this. Lots of great information. Actually, all of these have a lot of great information. Just another question. This is for either Shana or Brett. We had several people mention that they were disconnected during the webinar and want to know, are we going to be able to access a recording? So will we be posting the URL someplace for people to get the recording who registered?
If they have a problem with the video, they can contact us, and then we can go ahead and send them a recording. Otherwise, we will be sending out the slides later this week.
Okay, so thank you, Brett. And how should they contact you for getting the recording if they did. I have like 3 or 4 people who posted that they had issues.
Okay. Well, we'll work together for those people offline. We have a log of those messages. Plus, I'll go ahead and share my email address in the chat area right now.
Excellent. Thank you very much. And here's another one, either for Deborah or Stella. I've had some phone calls using this service before, but how do you return a phone call if the call gets dropped by mistake?
Deborah, I think that's a good one for you.
That is a good question. I guess it depends on if you were given their phone number, and then, so basically, my home phone number as a deaf person is basically through the relay service. So if I were to give you that phone number at the beginning of the call, and then you tried to call that number, you would automatically connect to me through a relay operator. So if you have that number, you know, the deaf person who called you gave you that number, then you're all set. You can just call them back, and you'll automatically be hooked up through the relay service. But if they didn't give you their number, then, you know, there's not really much you can do. I'm not sure if when you receive a call, maybe the phone number shows up on your phone. I do notice now with some of the new systems, if you get disconnected, then the interpreter might take charge and try to reconnect. I'm starting to see that more and more.
That was certainly the experience. That was what happened during the testing phase. If there was a cutoff, it was not assumed on the first try that that was intentional or discriminatory. So during the testing phase, if it was a hang-up or cut off, they would go back and they would recall the number and try to reestablish the connection. Most of those statements that I read to you were statements that happened after initial cut up or hang up. And then when they called back, these were the responses because it was they wanted to make sure the person understood they did not want to deal with them.
Right, and I was wondering the same thing that Deborah brought up, which was, does the TTY or the 711 number show up in your caller ID? If you have that ability to see the number of the caller, would that number show up even if the person didn't give you the number? Or is it masked or otherwise you can't get it?
I think a good best practice here for industry professionals would be, once you get the message from the relay operator saying this is a relay call, say, thank you, may I have your number in case we get disconnected. And then that way, that's a best practice on the industry side to make sure that there are no misunderstandings.
And that's an excellent suggestion. I know a lot of companies do that as a matter of practice because of the number of cell phones that are used today. So that's an excellent suggestion, Stella. While we're talking about best practices, I know you put several up there. What about people who come in and they have someone, for example, who signs for them, but you as the leasing person don't understand or know how to sign? Any suggestions on how to do that, accommodate that?
Well, I mean, if they have someone signing for them, that generally means that person is serving as a interpreter, so they should be able to communicate with you in vocally.
Vocally, okay.
Is that not correct, Deborah? I mean, in my experience...
I'm sorry, I'm not sure that I understand the question. Are you saying if a deaf person who brings someone who can sign, so that person that they've brought with them, are you envisioning that they're also deaf, or that that is a hearing person who's gone along with them?
It could be either one.
Well, if it's a hearing person, then the hearing person is going to relay back to you what is being said by the person who is deaf or hard in hearing in the same manner that a person would interpret for a person who speaks Spanish, for example.
Yeah, exactly. No, I understand what you're saying. Yeah, if the deaf person would like to bring a friend or a companion to interpret, that's fine. But the key thing to note is that the landlord or property manager can't require that the deaf person be the one who's responsible to provide the interpreter. If the deaf person, wants to bring their own friend, that's fine. But really, ultimately, it's the landlord's responsibility to provide the interpreter.
Well, and that brings up the question of reasonable. Stella, let me address that to you. That we're familiar with the definition of reasonable with regard to creating an undue administrative or financial burden. If we're talking about a very small community that has one employee, has limited resources, at what point does a determination be made about we simply can't afford to do that?
Reasonable accommodations and what is reasonable is determined on a case-by-case basis. Again, remember that the requirement is for effective communication for that language piece. But in terms of reasonable accommodations, you must allow a reasonable accommodation under the Fair Housing Act and the only way you can demonstrate and for reasonable modifications is at the expense of the tenant. So there is no financial burden there. And so when modifications are being done, then they're done at the expense of the person with the disability. But you must allow that to happen. In terms of reasonable accommodations, that's really focused on rules, policies, practices, and procedures. And so it would be difficult in most circumstances for that to be an issue when we're talking about the private sector. Because most requests are for rule changes. And again, most communities at the state and local level have requirements that you have those color-coded strobe lights. Those are safety measures that are generally required. So, and then in terms of the other common accommodation requests for parking spaces or for service animals, again, it would be case by case, and I have been privy to cases where what is reasonable is really determined by case. But the key thing, we can eliminate 30 to 35% of all fair housing discrimination cases involving reasonable accommodation with the first mantra, no is never the first initial response. That would get rid of 35% of the caseload. You cannot say no without having a discussion.
Got it. Okay, very good. Yeah, no's kind of shutting the door on it before you even know what the deal is, right?
Absolutely.
Okay, thank you. We've got two more questions that came in. Number one, this sounds like there's a huge gap between what communication services are available to communicate to the deaf and what is known by the general public or their education services available to bridge this gap. Certainly going to the NAD site would be my first suggestion. We've got the URLs up on the screen right now. Stella, what else? Where else could somebody go?
Well, you can go and talk with and have presentations done for you and your members through your local fair housing agencies. If you have a local community, human relations or community relations department in your city or your town, they generally carry information about fair housing rights and reasonable accommodation, and they will come out and do training for you for free. Those are your state and local government employees who have fair housing responsibilities. You can also contact HUD, and they have speakers who will come out and do workshops for you. And again, those workshops that are performed by HUD are generally free. You can also contact your local fair housing initiative program or local fair housing center. These are private fair housing groups, and so they would gladly do workshops for you, but they will charge you. And your local deaf and hard of hearing organizations is one that I know of. They always are available to come out and share with you best practices about their community's needs, and talk to you about the barriers that they face. So there are numerous locally available organizations as well as state and national organizations. Deborah, you could talk about the advocacy groups that assist the deaf and hard of hearing.
Yeah, I mean, I think really pretty much covered everything already, Stella. I would say that most states do have their own state association of the deaf, so like, you know, Iowa Association of the Deaf, et cetera, et cetera. And they're volunteer organizations, and as Stella said, very happy to provide that sort of advocacy and training and education. You can also contact the FCC, the Federal Communications Commission, and check out their website. They have a lot of information about relay services. That's fcc.gov. And I'm sure there's fcc.gov/something, but I don't remember the full address.
Excellent, thank you. We have what would a webinar be without a visitability question, Stella? How's this? Do you think the federal fair housing law requires a landlord to permit a tenant's visitor, so the visitor is deaf or hard of hearing, to bring in a trained dog to the tenant's apartment without notice to the landlord or without permission to the landlord, even if the tenant is not permitted by the lease to have an animal in the apartment?
Must allow reasonable accommodations. Section 804F2 of the Fair Housing Act covers those folks who are associated with. I want you to envision this, and because I want you to understand that every aspect of the Fair Housing Act protects people with disabilities. A landlord could not legally say to a tenant that you cannot have a black friend come and visit you if they were white. They cannot prohibit the access, and so the same right to have visitors, if you have family members who have difficulties, they are entitled to have a reasonable accommodation in your rule, policy, and procedure to visit their tenants. You may not ever prohibit service animals under both the Fair Housing Act and the Americans with Disabilities Act.
Okay. Very good. Well, that's the last question in the queue. Stella, any closing thoughts for us?
No, well, yeah, always. Remember that you're in the business of providing homes for people, places where people can live comfortably. And the Fair Housing Act just ensures that people have the right to live anywhere that they can afford, and for persons with disabilities, it provides some leveling of the playing field. I want you to imagine this and understand what a reasonable accommodation is. You have 3 soapboxes. You have a tall guy who can look over the fence and see the ball game. I know we all did this as kids if we live in rural areas. And you have a kind of medium-sized kid who is trying to look over the fence, and maybe he has access to a peephole. And then you have the little short kid, your little brother, and he can't see the game. And there are 3 soapboxes. Equality is that each one stands on the soapbox, 1 soapbox each. So the tall guy and the medium guy can now see. But the little short kid maybe has access to the peephole. But if you take those same 3 boxes, and the middle kid, the tall kid doesn't need a box. He can see over the fence. The medium height kid uses 1 box, so he can see over the fence. The reasonable accommodation is the 2 boxes that allow the 3rd kid to see over the fence. So whenever you're thinking about reasonable accommodations, just think about those 3 kids trying to watch their favorite player hit that ball out the park.
Excellent, very good. I'm seeing the kids right now, and it reminds me of, we all, I think, remember that fair housing's about equal opportunity. I think sometimes we don't remember it's about equal enjoyment. And equal isn't always equal when you think of it with your example. That was very graphic, and thank you for that. All right, well, Brett has put his address, Brent@multifamilyinsiders.com, if you had any problem, if you were disconnected, and let us know, and Brent will take care of you. I want to thank our sponsors again, Apartment Guide and MRI Software, as well as Multifamily Insiders, the NAHA and the Apartment All-Stars, and especially Deborah and Stella, thank you so much for the excellent information you shared with us. Please take advantage of the resources that Stella put up there. Go and visit the sites. And